Good morning, good morning, good morning, everybody. How y'all doing? Good morning, good morning. Thank y'all for coming in here this morning. This morning, we are going to be reading the sentencing memorandum that came out last night. So we can actually know that there's been some newspaper clippings that have come out that have told y'all that the exactly what the government is asking for. We are just going to read it. One thing that we do on this channel and most OCOV platforms, we don't just take newspaper clippings and say, hey, this is what it is. We like to know the, well, why, where, when, what, right? So we're going to break down exactly what they are asking for. And so everyone can have the actual inside scoop on exactly where they've come to the conclusion on what type of sentence they are asking for R. Kelly, which will be sentenced on, I believe, the 23rd of February. Okay. Let me see who up in here rocking with me this morning. I know it's early. Y'all like, Atmos, what are you doing up at 7 o'clock in the morning? I wanted to read this last night, but it was just, y'all, I was tired. I got a call from my bro at like 1:30 in the morning. I was like, bro, it's out. Let's get it. I'm like, bro, gotta go to work. So here we go. What's up, Granny? How are you? Thank you for coming in this morning. Black Diamond, good morning. Sonia Davis, good morning. Cherie Harris, good morning. Faith Burris, good morning. Mom Life Love, good morning. K-Love 92, good morning. Let me see. Cecilia Owens, good morning. Karen A, good morning. So y'all, we're going to go ahead and just get into this here, get this thing started. As you see strolling at the bottom, if anybody wants to say, you know what, Atmos, I'm going to help pitch in on this, because this stuff, I don't really complain about how expensive this stuff is, because I feel like y'all don't force us to come on here and read this. We do this voluntarily. But I would tell you this, whenever y'all do pitch in a little something, we don't reject it, because this thing adds up real quick. So if anybody want to be a blessing at the bottom, you can read it for yourself, okay? Before I get started, I got to give some shout outs to a few people that know what I'm about to go through right now. Shout out to Larry Grown Man, who the one who started doing this from the first place. Shout out to my bro. Shout out to Diva Divine Light. Shout out to, man, everybody who gets on here and reads these doggone transcripts. Shout out Hollywood Next. Shout out, when Deboski was on reading them, number one shout out I got to give it to is shout out to everybody who reads these things. Shout out to Angie Walker, because she's a lawyer and she gets this stuff and breaks it down for us. I don't think y'all understand how much time and energy it takes to do this. So shout out to Angie Walker for her contribution to helping us on these YouTube streets understand what is really going on from a legal aspect, okay? But shout out. Okay, let's get into this, y'all. This right here, if I missed you, please forgive me. It's just early, and I just want to get this done before I got to go to work. All right, here we go. This right here, matter of fact, let me take this off right here so y'all see everything. Okay. United States District Court, Northern District of Illinois, United States versus Robert Sylvester Kelly, Defendant Kelly's sentencing memorandum. This is Jennifer Bonjean. Says here, introduction, brief factual background, argument, all of these little things here. This is like the table of contents we are about to go through and try to knock this out. So here's the introduction to this, y'all. This was put out last night, early in the morning. I'm talking about early in the morning, okay? So here we go. Introduction. Robert Kelly, 56 years old, is currently serving a 30-year sentence of incarceration dispensed by the United States District Court of, actually, I think, hold on. Let me make sure I got this right. So this was put out by United States of America. Okay. So Jennifer Bonjean. Okay, here we go. 30-year sentence of imprisonment for an African-American man with diabetes is a life sentence, statistically speaking. Okay, so this was Jennifer Bonjean's suggestion. This is, what's up, Ty? Good morning. This is Jennifer Bonjean's suggestion on the sentence that he should get. Okay, so here we go. Let's read this. So she says a 30-year sentence of imprisonment for an African-American man with diabetes is a life sentence, statistically speaking, because the crimes for which Kelly was convicted in this prosecution could have and should have been brought pursuant to the EDNY Racketeer Influence and Corrupt Organizations Act, which is the RICO prosecution. Significant incremental punishment is not warranted, particularly where Kelly is already serving a de facto life sentence. Okay, so here we go. As fleshed out below, the EDNY prosecution charged Kelly with RICO under a theory that he engaged in a pattern of racketeering activity between 1994 and 2008 as a part of an enterprise that had the purpose of recruiting women and girls to engage in illegal sexual activity and to produce child pornography. This was in a superseding indictment. The charges brought in this district could have been brought in the EDNY indictment since the conduct alleged in the prosecution occurred during the relevant time period and was covered by the purpose of Kelly's alleged RICO enterprise. Kelly faced a guidelines range of life in prison in the EDNY case and was sentenced to 30 years. As a matter of fairness, double jeopardy, Kelly should not face consecutive sentences where piecemeal prosecution. Piecemeal prosecution. Wow. Okay. Where piecemeal prosecution by a federal government was designed to unfairly enhance his punishment. The federal government obsession. Bonjean said the federal government's obsession with ensuring that Kelly dies in prison is particularly troubling, where it seems to have no appetite. Here's a footnote. The United States Sentencing Commission preliminary quarterly data reports indicates that a person held in a general prison population has a life expectancy of about 64 years. People versus Buffer. Okay. Acknowledging. Thank you, whoever said that. Thank you so much. Acknowledging that acknowledging the decreased life expectancy for incarcerated individuals based on United States Sentencing Commission data. Okay. So it says here, investigating or initiating prosecutions of numerous other famous white musicians. Here we go. White musicians with credible stories of sexually abusing underage women. This is going to be good, y'all. What's up, DJ D Money? What's going on? Lady D, what's up? I'm Queen Newton. Good morning. It says, as set out below, Kelly accepts that he faces a mandatory prison sentence of 10 years in connection with his convictions here. However, Kelly contends that his guidelines range is 135 to 168 months imprisonment. The government inappropriately places the range higher at 168 to 210 months imprisonment on the erroneous claim that the inducement counts carry higher adjusted offense levels than they do, because Kelly did not use physical force, threat of force, or tactics, instilling fear in Jane, Pauline, or Nia to gain their compliance in the prohibited sexual conduct. That's not true. That's not true, because if she didn't do what he told her to do, he would beat her. He would chastise her. So, and then if she didn't do something right, he would tell her, do it over again, do it over again, do it over again. If that's not using physical force when he whoops her and spanks her, and threats of force, or tactics instilling fear in her, I don't know what is. I'm confused, but okay. Let me see. Government's efforts are artificially raise the offense level of the inducement counts must be rejected. When considering the factors set forth in 18 U.S.C. 3553, including Kelly's significant mitigation evidence and the fact that he is already serving a 30-year sentence for a pattern of racketeering activity that could have included the conduct alleged in the NDIL indictment, A concurrent sentence at a lower end of the guidelines range is sufficient, but not greater than is necessary to comply with the purposes of sentencing. A consecutive sentence will serve no specific deterrent, as Kelly is likely to die in prison either way. Even if he beat the statistical odds, he would not be released from prison until well into his 80s, long after he is a threat to any kind of general public. Diva Divine Light. I got you, Diva. I'll send it over to you. I will send it over to you, sister. I got you. General public. A consecutive sentence serves no general deterrent purpose either. At least no stronger purpose than what has been accomplished with his EDNY sentence. Since the government and society at large, talking about y'all, talking about us, society, right, have reserved a unique, unprecedented contempt for Kelly that is wanted as his similarly situated white counterparts. Oh, here we go. Drop this race crap. This ain't got nothing to do with no freaking black and white. Here we go. White counterparts. In fact, iconic white musicians such as Elvis Presley, who married his 14-year-old girlfriend, are currently being celebrated as in Academy-nominated movies. In contrast, the government argues that one life sentence isn't enough for Kelly. No one will be deterred by a consecutive sentence in this case because no one believes that they will ever face the punishment Kelly has faced for some of the same exact conduct. This court is tasked with sentencing Kelly to an appropriate sentence that addresses the harms a jury found he caused, but an appropriate sentence is a lower guidelines range sentence, runs concurrent with the EDNY case, which is the functional equivalent of a life sentence. Such a sentence punishes Kelly for conduct that is over a quarter century old, while taking into account his individual characteristics that include his own horrific child abuse that shaped him, and provide some explanation, not an excuse, for the conduct that underlies his convictions in this case. So she's trying to say, well, oh my God, it was like 25, 30 years ago. It's a quarter century old. Why y'all still tripping about that? I mean, look at him now. Look at what he went through when he was a child. I mean, look, I get it, but that ain't got nothing to do with what he was doing just a few years ago. Okay? Just my opinion. Brief factual background. Kelly was convicted of three separate offenses of 18 U.S.C. 2251, stemming from the creation of three videos depicting sexual conduct with Jane, who testified that she was 14 years old at the time the videos were created. Ooh. Let me read that little part one more time. This is stemming from the creation of three videos depicting sexual conduct with Jane, who testified that she was 14 years old at the time the videos were created. Stamp. Period. End of story. Who recorded it? R. Kelly did. With who? A 14-year-old. Just saying. Defendant was also convicted of violating 18 U.S.C. 2422 as to Jane, whom he had a relationship that lasted roughly 12 years. Oh, so that makes it better that he groomed her for... Okay, fine. The jury returned two additional guilty verdicts for violations of 18 U.S.C. as to Nia and Pauline. Nia testified at trial that Kelly fondled her in a hallway at his studio on a single occasion when he was 29 years old and she was either 15 or 16 years old. Nia testified that the isolated encounter occurred in the summer of 1996, but she could not state precisely when the incident occurred. Pauline testified that she began engaging in sexual conduct with Kelly when she was 15 years old. The prohibited sexual relationship endured long after Pauline became an adult and she considered Kelly her boyfriend. Kelly was acquitted of all remaining counts in the indictment. Here's the argument. The argument is that a district court should begin all sentencing proceedings by correctly calculating the applicable guidelines range, which should be the starting point and the initial benchmark. So they cite some case law. After a proper calculation, a sentencing judge considers the 7 factors set forth in 18 U.S.C. The nature of the circumstances of the offense and the history and characteristics of the defendant, the 4 legitimate purposes of sentencing as set below, the kinds of sentences available, the applicable guidelines range itself, and relevant policy statement by sentencing commission, the need to avoid unwarranted sentence disparities among defendants, and the need to provide restitution to any victims. In determining the appropriate sentence, the statute directs judges to impose a sentence sufficient but not greater than necessary to comply with the purposes of sentencing, which are A, to reflect the seriousness of the offense, to promote respect for the law, and to provide such just punishment for those offenses. B, to afford adequate deterrence to criminal conduct. C, to protect the public from further crimes of the defendant. And D, to provide the defendant with needed educational or vocational training, medical care, and or correctional treatment in the most effective manner. So these here pretty much already spelled out. What's up, Miss Me, Miss Mo? Vanetta M, how y'all doing? Good morning. So these here are pretty self-explanatory. So she's saying that that they should impose a sentence that's sufficient but not greater than necessary to comply with the purposes of sentencing, which are A, to reflect the seriousness of the offense, right? To properly give punishment that is in correlation with the seriousness of his actions towards these young ladies, babies, kids. To promote respect for the law. He did break the law, so you got to respect that. Yes, you got to give him a sentence because he did break the law. And to provide just punishment for the offense. I don't know what a just punishment could be for ruining multiple women's lives, giving them an incurable disease, putting them out with your team of terrorists online, doxing them, going up to their jobs, harassing them, posting their addresses, getting people kicked out. I don't know what kind of time you can put on that. B, to afford adequate deterrence to criminal conduct. Well, an adequate deterrence from him being able to stop doing this is to stay his ass in jail and be around the other men that he, I hear he likes to go that way too. C, to protect the public from further crimes of the defense. Well, you can protect the public, but keep his ass in prison. That'll help protect the public. Keep him in prison. Keep him off the doggone phones. Good gosh, all the things this man making moves from jail. And D, to provide the defendant with needed educational and vocational training, medical care, and other correctional treatment in the most effective. He does need help. The man does need help. Get him the help that he needs. Okay? Now, the guideline sentencing range is 135 to 168 months imprisonment. The defendant's guidelines range for the instant case is 135 to 168 months imprisonment, not 168 to 210 months as the government argues. Here's a footnote. The range is certainly not as probation contends, when probation clearly did not read the testimony of the complaining victims, ripping much of the PSR, which is the pre-sentencing report, from the EDNY case, and demonstrating a concerning bias where it attributed it to a criminal history point to Kelly based on, and then it'll continue. So A, ex facto, ex post facto. The government advocates application of the 1997 federal sentencing guidelines. Kelly agrees that in 1997 sentencing guidelines should apply when the sentence for the defendant was convicted occurred prior to 2000. Probation applies the 2000 sentencing guidelines. Probation applies to wrong guidelines, but not seem to impact the guidelines range. So the offense levels counts 1 through 3. The child pornography counts. Base level offense, 27. Adjusted offense level, 29. The defense agrees that the government agrees with the government that the base offense level is 29 pursuant to guideline 2G2. Defendant further concedes that the 2-level enhancement is appropriate pursuant to 2G2 because Jane was over the age of 12, but under the age of 16. Hold on. The defendant further concedes that a 2-level enhancement is appropriate because Jane was over the age of 12, but under the age of 16. Does that mean that he is admitting that he was with her under the age of 16? It says the defendant further concedes, which means he agrees. This will be true whether applying 1997 or 2000 guidelines. Number 2, count 9, inducement count as to Jane. Unsourced internet article. In its recommendation of a maximum guideline sentence, probation did not even accurately summarize the conduct for which Kelly was convicted. For example, probation summarized conduct related to Nia that was neither pled in the charged instrument nor related to the count for which Kelly was convicted. Probation claims that Kelly's conduct against Nia was not a 1 or 2-time occurrence, when it was precisely a 2-time occurrence and did not involve anything more than touching. In its recommendation, probation relied heavily on the facts that a jury expressly rejected and even invented facts. They say, wow. They saying that, what? Hold on. Occurrence and did not involve anything more than touching. In its recommendation, probation relied heavily on facts that a jury expressly rejected and even invented facts, wow, that were never alleged by anyone. A jury projected that the government's evidence that Kelly enlisted people to retrieve contraband. The jury acquitted all 3 defendants of receiving child pornography, which demonstrates that the jury clearly rejected the government's claim that Kelly enlisted persons to obtain any tapes. Probation seems to have blatantly ignored the jury's verdict to the extent that it benefits Kelly. Probation even boldly claims in its recommendation that Kelly began blackmailing Jane. This is nothing short of a fabrication. In sum, probation did not do its job. It demonstrated extreme bias and a lack of competence in putting together the PSR report. Its recommendation should be ignored. Girl, bye. Base level. base level 15, adjusted level 15. The base level for this count is 15 pursuant to, they cite TGI and 2A3. The parties agree that the starting point for calculating an offense level for the indictment counts is 2G1, but the parties disagree on which cross-reference subsection applies, if any section. Number 2, if the offense involved criminal sexual abuse, attempted criminal sexual abuse, or assault with intent to commit sexual abuse, apply 2A3.1, criminal abuse, attempt or assault with intent to commit criminal sexual abuse. If the offense did not involve promoting prosecution, and neither subsection, C, number 1 nor 2, if applicable, use the offense guideline applicable to the underlying prohibited sexual conduct. If no offense guideline is applicable to the prohibited sexual conduct, apply 2X5.1. The application does not provide that the cross-reference of subsection 3 addresses those cases where the offense did not involve promoting prostitution and either not applicable and includes such prohibited sexual conduct as criminal sexual abuse of a minor under 18. Contrary to the government's position and the position of probation, Kelly's sexual contact with Jane did not involve the offense of criminal sexual abuse or aggravated criminal sexual abuse as defined by federal law and the law of this circuit, since it did not involve force or the threat of force or the use of fear to engage Jane in prohibited conduct. Accordingly, cross-referencing is prohibited. That's not true. Because there was times that he forced, you know what? Hold on, this is RL. I believe he forced RL to have sex with people too. I believe he coerced her and had her have sex with people that were much older than her, have sex with other women. I'm sure this wasn't something that she volunteered. She was coerced and probably threatened and probably beat and probably forced to do all the things that he told her to do. She did what he told her to do. What's up, Mom Life? Mom Life said he has no choice but to agree. Okay. What's up, Diva Time? Let's see. Section 2A3.1 of the sentencing guidelines applies when the defendant has committed the offenses of 18 U.S.C. 2241 or 2242. A comment: a violation of 18 U.S.C. 2241, also known as aggravated sexual abuse, can be reached when a person knowingly causes another person to engage in sexual conduct by forcing against that person, by using force against that person. He did this. This was his routine. He would knowingly videotape these girls and make them have sex with either other girls, make them have sex with other men, make them have sex with gay men, make them have sex with each other, make them have sex with I'm just saying. Okay. By using force against that person, by threatening or placing that other person in fear that any person will be subjected to death, serious bodily injury, or kidnapping. Force in the exertion of physical power upon another to overcome that individual's will to resist. There's some case law. The Seventh Circuit has expressly rejected the interpretation of force to mean psychological coercion rather than physical force. I see what she's trying to do. She trying to use this case law to say that although he might have mentally messed them up, he might have, mentally, psychologically messed them up and made them do what he wanted them to. He might have manipulated their young minds to do what he wanted them to do, and might have bribed them and gave them money and bought them cars and gave their parents money and all this kind of stuff. But as long as he didn't physically force them to do it, which he did, I'm just saying. Emphasizing that in order to convict on aggravated sexual abuse, the jury must find the defendant used actual physical force against the victim or made a specific kind of threat like fear of life, serious bodily injury, or kidnapping. That is exactly what he did, you crazy wench. Are you crazy? You are explaining exactly what he did to these girls and trying to act like you didn't know. Man. Section 283.1 of the sentencing guidelines would also apply if Kelly committed a violation of 18 U.S.C. Notably, the government did not charge Kelly with a violation of 18 U.S.C. 2242 and the jury was never asked to decide whether the elements of the sexual abuse were satisfied. A violation of 18 U.S.C. 2242, also known as sexual abuse, requires that the government prove that the defendant knowingly causing another to engage in sexual act by threatening them or placing them in fear. Oh my gosh. Are you freaking kidding me? Did this Bonjean lady even read any of the testimony? Was she there? Wow. Okay. The fear contemplated by section excludes such fear that a person will be subjected to death or serious bodily injury, but encompasses the use of any kind of threat or other fear inducing coercion to overcome the victim's will. And they got some case law here. The record fails to reflect any evidence whatsoever that Kelly used fear or threats to coerce Jane into prohibited sexual conduct. The government never claimed as much at trial. In a highly instructive case, United States versus Law, a jury convicted the defendant, read a law of sex trafficking and forced labor. Law owned and operated 3 massage spas and offered sex services to its customers. 2 of Law's employees, HV and XC, who were born in Vietnam and China, respectfully traveled to work for Law at her massage spas. They spoke no English and had no support systems in the United States. The evidence at trial revealed that once the spa, Law forced HV to provide sex services to customers by claiming that HV's husband owed her a debt that HV had to work at the spa to pay off Law. Law bullied XC into providing sex services and demanded money for room and board. HV and XC were pressured into working at the spas under brutal conditions, were not permitted to leave the spas unaccompanied, were denied hourly wages and adequate food. Law confiscated HV and XC's passports and threatened to have them arrested if they did comply. If they threatened to have them arrested if they did comply with her demands. I guess she meant to say if they didn't comply with her demands to provide sex services. Law also physically intimidated the women. On one occasion, when HV called Law and told her that she was experiencing severe bleeding and fearing a miscarriage, Law did nothing and forced her back to work at the spa. Oh, wow. Okay. What the hell does this got to do with R. Kelly? Let's read on. Law, nothing, hold on. On occasion, when HV told her she was experiencing severe bleeding and fearing a miscarriage, Law did nothing and forced her back to work at the spa and the following afternoon. On appeal from her sex trafficking and law labor convictions, Law challenged inter alia the district court's application of 2A3.1 of the sentencing guidelines as defendant does here, challenging the fear element of 2242 violations. The Seventh Circuit affirmed finding that Law had placed HV and XC in fear in the number of ways, including threatening to have them arrested, threatening them financially, and threatening them physically. In contrast, the record is devoid of any evidence whatsoever that Kelly either threatened Jane or placed Jane in fear of any type of harm. At no point during her days of testimony did Jane testify that Kelly made her feel fearful and that was the reason why she engaged in prohibited sex with him. First of all, you just used the wrong word, because it was never prohibited for him to be having sex with this 14-year-old girl. It was never prohibited for him to have sex with this 15-year-old girl. It was never prohibited for him to have sex with this 16-year-old girl. Or 17, because we under federal, which is 18, is the minimal age of consent. So you put prohibited. No, this is unprohibited. This is not prohibited. This is not allowed. Okay? She engaged in prohibited sex with him. Indeed, the government's entire theory, as kicked off by Dr. Turner's testimony, was that Kelly groomed Jane, which he did, manipulated her, which he did, and induced her into prohibited sexual. Actually, no, prohibited means that it's not. Okay, yes, it's just right. Yeah, prohibited means that it's. Yeah, unprohibited. Okay, yeah, prohibited means it's not supposed to happen. Sexual conduct through a number of ways. But the law prohibit it for those under 18. Prohibit. Okay. And induced her into prohibited sexual conduct through a number of ways. But there is simply no evidence that threats or fear was a tactic utilized by Kelly. Caleb92 says, so all her arguments about 17 being the age of consent are void. This is federal, crazy ass. Exactly. Let's continue. Jane testified about how the relationship first turned physical when she was 14 years old. So we were sitting in the office area of the studio on the couch, talking and watching TV. First of all, you know what? Let me just read. So we were sitting in the office area of the studio on the couch, talking, watching TV, and obviously we had begun phone sex. At this particular time, it became more physical with touch of the breast and him rubbing on her vagina area. Jane explained that the sexual contact eventually escalated. Okay? When asked why she engaged in sex talk with Kelly, she responded, I just kind of went with the flow. She said that he was the adult and that she looked up to him. So again, I went with the flow. That means that she was not mature enough legally, mentally, physically to consent. Duh. Caleb92 said, yeah, technically in Illinois, it's 17, but the older person cannot be over 5 years older than the team, the Juliet law. Indeed. So when asked why she engaged in sex talk with Kelly, she responded, I just kind of went with the flow. She said that he was an adult and that she looked up to him. So again, I went with the flow. Although at one point in her testimony, Jane testified that she participated in the prohibited sexual conduct because of intimidation. She immediately explained that Kelly was an adult and that she looked up to him. She called herself a passive person and stated, I just kind of went along with things and then it somewhat became normal. Hold on, Bonjean. Are you serious right now? So she said he did use intimidation. You have the facts here that he had sex with her or that he did sexual things with her when she was under the age of what you say should be consent, which is 17. And you're still sitting here trying to justify it because she says she looked up to him. And she called herself a passive person and stated, I just kind of went along with things. And then it somewhat became normal. Bonjean says Jane did not say she feared Kelly or that he said or did anything to install any type of fear in her that caused her to have sexual contact with him. Didn't you just say that Jane testified that she participated in prohibited sexual conduct because of intimidation? Hold on. Let me go back up. Bonjean, you said, although at one point in her testimony, Jane testified that she participated in the prohibited sexual conduct because of intimidation. And now you're saying down here that Jane did not say she feared Kelly or that he said or did anything to instill any type of fear in her, which caused her to have sexual contact with him. Last time I checked, if a person is intimidated by somebody, that can also be that they fear them too. Since when is fear not associated with intimidation? I'm confused. I'm really not confused, but I'm confused at the way this lady is thinking. When asked to elaborate why she had sexual relations with Kelly, Jane testified, I started having feelings for him. First of all, don't no 14 or 15-year-old understand nothing about no damn love for no grown-ass man. That is not genuine. She said, I started to develop feelings for him, and I felt good about our interactions. That he loved me, that he would take care of me, that he was my protector. Jane repeatedly stated that Kelly made her feel good. Jane repeatedly stated that Kelly made her feel good. So you got this 14 or 15-year-old little girl who is stating that she developed feelings for this grown-ass man and that she felt good about their illegal interactions and that he loved me, and that he would take care of me, and that he was my protector. First of all, your protector should have been your father. Your protector should have been your mother. Your protector is God Almighty. This man is sick. He had to teach this girl this kind of stuff. I'm your protector. I love you. I'm going to take care of you. You ain't got to worry about nothing. This shit's sick. Let's move on. Although the government may have plenty to say about Kelly's tactics in inducing Jane into a sexual relationship when she was underage, the use of threats or fear was not why Jane engaged in sex with Kelly during the first 5 years of their decade-long relationship. You think just the government may have plenty to say about Kelly's tactics in inducing Jane into a sexual relationship while she was underage? And thank you for admitting that, by the way. Thank you for admitting finally that he did induce her into having a sexual relationship when she was underage. Jane testified that the relationship turned darker after Mr. Kelly was acquitted in 2008. When asked how the relationship changed when Jane testified, it changed after the trial was complete. It changed for the worse as far as other women being involved, as far as abuse coming into play and things of that nature. Jane was 23 or 24 years old at the time that R. Kelly was acquitted when the relationship allegedly changed. A fair and honest review of Jane's testimony leads an inescapable conclusion that the application cross-reference provision, because Kelly's conduct as described by Jane arguably satisfies the elements of 18 U.S.C., not 18 U.S.C. 2243, not 18 U.S.C. 2242 or 2241. So y'all, let me correct myself. So prohibited is bad. Prohibited is bad. So let me correct myself. So prohibited is not good. Okay. Knowing engaged in sexual act with another person who has attained the age of 12 but has not attained. Let me make sure I read that again. Section 2243. A. The sexual abuse of a minor occurs when a defendant knowingly engaged in a sexual act with another person who has attained the age of 12. Who has attained the age of 12 but has not attained the age of 16. Is at 4 years younger than the person so engaging. To find the defendant guilty of the inducement count, the jury had to concede that the defendant violated the Illinois Aggravated Criminal Sexual Abuse Statute, which generally incorporates in different subsections 18 U.S.C. 2241, 2242, and 2243. The government's proposed jury instruction only, they're emphasizing the word only included a theory related to statutory rape and did not ask the jury to consider whether the defendant used threats or force. The jury was instructed to find the defendant guilty of the inducement counts. It it had to find beyond a reasonable doubt that a person commits aggravated criminal sexual abuse if a person commits an act of sexual penetration or sexual conduct with a victim who is at least 16 years of age but under 17 years of age. The person is at least 5 years older than the victim. He checks off all of those marks. He violated each one of those marks. Each one. The language is akin to the elements 2243, not 2241 or 2242. It says a person is capable of committing aggravated criminal sexual abuse under Illinois law by using threats of force, but the evidence was so lacking, the government did not even bother to offer this instruction to the jury as an alternative means of finding a violation of the statute. They didn't need to. Now y'all want to talk about overkill? That would have been overkill. I mean, did you not? Did any of y'all remember in the NDIL trial when the government went up there and they had a sidebar, and the government said, "Oh, we got this video. Can we play this? Please, judge, please." And the judge was like, y'all got enough. Y'all got plenty. Just take that whole damn barrel of videotapes or whatever. Leave it over. Y'all don't need all that. Y'all got enough. He's done. Just please stop. That's overkill. Okay? Please. It says here, Jane described Kelly. Now, let me read this. Let me go back up a little bit. It says the record speaks for itself. Jane did not testify that Kelly used threats of any kind or said anything that created a fear that compelled her to engage in prohibited sexual behavior. That's not true. You just said, Bonjean, that on an occasion, Jane testified that he did use intimidation to get her to do a prohibited sexual act. Now you're saying that the record speaks for itself that Jane did not testify, which you just said she did testify, that Kelly used threats or any kind of, or said anything that threatened a fear that compelled her to engage in prohibited sexual behavior. Quite the opposite. Jane described Kelly as showing her affection and love that caused her to participate in prohibited sexual conduct. This is sick. See, let me tell y'all something. This is why we read right here, because these lawyers will slip little stuff in here for those people on the other side who don't read a damn thing. And they'll take one little part and they'll say, see y'all, right here, it says that that Rashana never said that R. Kelly intimidated her. But they don't read the other part. They don't read the whole thing. That's why it's so hard to listen to those other channels. They won't read this stuff and break it down. This lady is talking out both sides of her. You know what? One minute she say that Rashana got on the stand and said that he intimidated her into having prohibited sex. Now right here you saying that she testified that the defendant later engaged. Let's continue. That Jane testified that the defendant later engaged in some sexual abuse behavior after he was acquitted in 2018 is irrelevant to whether he used threats or fear to gain her compliance with prohibited sexual behavior. Accordingly, there is no evidentiary basis to support application of the cross-reference. The most applicable cross-reference is 2G1.1C3 and 2A3.2, which means that the adjusted offense level for this inducement is 15. Y'all, she just kind of threw a whole bunch of stuff in there, contradicted herself and everything. See, that's for these people that don't read. Yeah. Here we go. Number 3, count 10. Inducement count as to Nia. Base level 15, adjusted offense 15. As was the case in count 9. The base offense level for count 15 pursuant to 2G1.1 and 2A3.2 as argued supra. The record is devoid of any evidence the defendant used forced threats of force, threats of any kind, or fear tactics to engage Nia in prohibited sexual conduct at his studio when she was 15 or 16 in the summer of 1996. Nia testified unequivocally that she met Kelly in the mall in Atlanta when she was 15 years. Oh, God. Y'all, just to read this makes me sick, to be honest with y'all. Here we go. Met in the mall in Atlanta when she was 15 years old, and he invited her to a concert. It's supposed to be 18 years or older. In Minneapolis, Nia explained that she was attracted to Kelly and had romantic feelings for him. Girl, sit your little ass down. She stated that she spoke to him numerous times by telephone and she felt very good. When she spoke to him and she looked forward to seeing him, Nia testified that she traveled to Minnesota for the concert and called Kelly when she arrived. She attended the concert but only saw him the following morning when he came to her hotel. Nia testified that Kelly kissed her at 15, touched her breast at 15. Alexa, stop. Kissed her breasts and then masturbated with her at 15. Kelly told her he wanted her to come to Chicago and she accepted the invitation. Kelly did not follow up on the invitation and did not book any arrangements for Nia to come to Chicago. However, Nia made her own arrangements and went to stay with family in Chicago that summer, unbeknownst to Kelly. Here she go. Nia called Kelly and he invited her to his studio, but made no arrangements to get her there. Oh, get the hell out of here. Get out of here. But made no arrangements to get her there. Nia convinced her cousins to take her to the studio. Nia arrived at the studio with her cousins, and Kelly showed them around and took them to a waiting area where they could see him record. Nia and her cousins stayed most of the evening, but Kelly was recording and was not hanging out with Nia and her cousins for most of the evening. At some point, Nia was told Kelly wanted to talk to her in the hallway, and Nia went to the hallway to see Kelly. Nia testified he greeted me with a hug, with a kiss, and held on to her for a moment. And they kind of made out a little. Nia elaborated, I remember with his hand being around my waist, on my bottom, my butt, and then he mentioned his hands into my pants as we kissed. And he fondled my breast and he, kissed. We just kind of made out between the time frame that we were in the hallway. Nia stated he touched my vagina at 15 and he caressed my bottom at 15, my behind. Nia testified that before she left, she had a similar encounter with Kelly. She stated that they embraced, hugged, he held on to me, held my bottom, and things of that nature, It wasn't as long as the first one. It was more like, kind of like goodbye, see you later. Oh, gosh. Let's move on. Nia never saw or spoke to Kelly again. But in 2022, Nia sued Kelly, and the case was settled for $500,000. There's not a single word in Nia's testimony from which any jury or any judge under any standard or proof could find that infer that Kelly used threats or fear tactics to engage Nia in prohibited sexual contact. Nia was extremely forthcoming when she testified, and she approached Kelly for an autograph in Atlanta, and they spoke on the phone, and she was excited when he invited her to Minnesota to see a concert. So excited that she bought him a red rose on the way there. Why in the hell would a 15-year-old bring a grown-ass man a red rose? Unbelievable. Nia admitted, right there, as to the charged offense in Chicago, Nia admitted that she went to Chicago to see him and contacted him, not the other way around. There was a quick encounter in the hallway at his studio where he fondled her, they embraced and kissed, and Kelly touched her vagina area. Nia was hurt and upset when Kelly did not return her phone calls after that encounter. The government cannot point to testimony. First of all, the only reason why he wanted to get her in the hallway by herself was because he wanted to get her away from her cousins. Because they were there to look after her. The government cannot point to testimony whatsoever that suggests that the defendant committed an act of sexual abuse pursuant to 18 U.S.C. 2241 or 2242. The applicable statute in this case is 18 U.S.C., which is incorporated into the Illinois criminal sexual abuse statute on which the jury was instructed. As such, the applicable cross-reference is 2G1.1 and 2A3.2, which means that the adjusted offense level in this inducement count is 15. T-Bam 1, what up? What up, T-Bam 1? Good morning, Ronnie Lyles. Good morning. Thank you for coming in. Number 4, count 12, inducement count as to Pauline. Base level offense 15, adjusted offense level 15. As with the prior inducement counts, the base offense level for this count is 15, pursuant to 2G1.1 and 2A3.2. Pauline's testimony is devoid of any claim that the defendant threatened her, physically or otherwise, or instilled fear in her to gain her compliance and prohibited sexual conduct. Pauline testified that after she discovered Kelly and Jane engaged in sexual conduct, she began engaging in sexual conduct with Kelly and Jane. Pauline considered Kelly her boyfriend and stated that she loved Kelly. When asked the objectionable question of why she was testifying, Pauline testified that she takes responsibility for having sex with Kelly, and she probably could have just said no, but she loved him. Pauline's testimony in the trial. Pauline offered that she still loves him and that he was like best friend meets boyfriend meets dad in one person. Wow. Good morning, Lizette Martinez is in the building. Good morning, Queen. How are you? How are you, Lizette? Yep, there you go. There you go, Lizette. Lizette said these girls were underage. Case closed. I agree. And she said, good morning, beautiful ladies and gentlemen. Y'all welcome Lizette Martinez to the chat. Thanks for coming in. Okay? So as y'all see here, Pauline says that she still loved him and that he was like best friend meets boyfriend meets dad in one person. That is so sick. What woman would want to have sex with someone who reminds them of her dad? Unbelievable. While the government's argument that Kelly groomed Jane and Pauline and induced and exploited them in manipulative ways is fair game, the government cannot convert this testimony into a claim that Kelly used threats of fear to compel the prohibited sexual conduct with Pauline or any other victim. In addition to the testimony itself, this court should look at the government's closing argument. The government never once argued that Kelly used any types of threat or fear to compel the prohibited sexual activity. There is no evidentiary support for the government at probation's claim that Kelly used threats of fear to gain Jane, Pauline, and Nia's compliance as such in the offense level of 27. Adjusted offense level of 29 for the inducement counts is not permissible. Grouping. The defendant concedes that the production of child pornography is not a groupable offense pursuant to USSG 3D1, notwithstanding that the counts all involve the same victim. Criminal history category. The defendant and the government agree that Kelly's criminal history category is 2. Probation contends that Kelly's criminal history category is 3 because an unidentified internet source reveals that he pled no contest and received unsupervised probation in 1997 in connection to a simple battery charge. Probation admits that it has been unable to obtain any court records that reflect Kelly's plea of no contest, his sentence, or proof of how the case was resolved. Instead, it relies on the unsourced internet article containing information that was allegedly obtained from proceedings or from pleading in a related civil case. Probation cannot even identify the internet article of which it relies. Critically, Mr. Alper, who prepared the PSR, which is the pre-sentencing report, contacted undersigned counsel earlier this week and conceded that the law enforcement representative from Louisiana informed him that an arrest and disposition from 1996 Louisiana arrest was expunged, but Mr. Alper has yet to amend the PSR to reflect that Kelly should not receive a criminal history point for this incident, since expunged convictions cannot be counted towards criminal history points. An unidentified internet source is hardly reliable information on which probation should be relying to increase Kelly's criminal history category. In applying the guidelines range must be established by the government of preponderance of reliable evidence. They cite some case law here. The commission believes that the use of preponderance of evidence standard is appropriate to meet due process requirements and policy concerns in resolving issues or disputes regarding the application of guidelines to the facts of the case. The court may consider relevant information without regard to its admissibility under the rules applicable at trial, providing that the information was sufficient indicia and reliability to support its probable accuracy. They cite more case law. A district court may consider hearsay evidence in determining a defendant's sentence, but the hearsay evidence must be reliable. Probation can offer no reliable evidence that shows that Kelly pled no contest to a simple battery in 1997 for a sentence of unsupervised probation that was not expunged. Okay? What's up, Karen Johnson? What's up, Lady D? So here we go. So another footnote here. Demonstrating probation's clear bias against Mr. Kelly, Mr. Alper told undersigned counsel that he was trying to get further information about the expungement with the help of the government. Mr. Alper explained in sum and substance that he couldn't just rely on the hearsay statements of the law enforcement official in Louisiana. That's just how we do things. Only. It's exactly how probation did it, and they hit Kelly with a criminal history point based entirely on an unsourced internet article. Presumably, the hearsay statement of the law enforcement officer is more reliable than an unidentified internet article. Apparently, hearsay is only unreliable to probation when it works to the benefit of Kelly. Okay? Let's move this up. It says here, incident happened at all. It seems obvious that it was expunged based on the representations of a law enforcement official in Louisiana and the fact that no documents from the proceedings are available. Expungement aside, an unsourced internet article that probation cannot even cite based on some information about a civil case that references a prior criminal case is not reliable evidence. Indeed, the evidence is not mere hearsay. It constitutes 4 or 5 levels of hearsay and lacks foundation since probation does not even identify the mystery internet article that serves as a source of the information. An unknown internet reporter for an unknown online publication obtained information from a civil court proceeding or document that apparently referenced a distinct criminal proceeding for which there is no available records and that reported that information is unknown, unnamed internet article. This information is not sufficiently reliable to raise Kelly's criminal history category. Thus, Kelly's criminal history category is 2. Combined offense level. The combined offense level is 32. It instructs the offense level applicable to a group of the highest offense is 29, which relates to 1 child pornography count, which Kelly was convicted of 2 additional child pornography counts, which are equally serious. 3 levels are added to the highest offense level of 29 for a total combined offense level of 32. Because the inducible accounts have adjusted offense levels of 15, as discussed supra, they do not increase the offense level. According to Kelly's guidelines, range 135 to 168 months imprisonment, the defendant concedes that he is subject to a statutory minimum sentence of 10 years imprisonment. The sentence should run concurrent to Kelly's 30-year EDNY sentence. Pursuant to USGG, the sentence in this case may be imposed concurrently, partially concurrently, or consecutively to the prior undischarged term of imprisonment to achieve a reasonable punishment for an instant case. Application Note 4 directs the court to consider the following factors. So these are the things that they're asking them to consider. A, the type. Determinate, indeterminate, parolable, and length of the prior undischarged sentence. B, the time served of the undischarged and the time likely to be served before release. C, the fact that the prior undischarged sentence may have been imposed in state rather than federal court or at a different time before the same or different federal court. And D, any other circumstances relevant to determine of an appropriate sentence for the instant office. The foregoing factors militate in favor of a concurrent sentence. Kelly has been sentenced to 30 years, which is discussed supra a tantamount to a life sentence. According to data complied by the Sentencing Commission, the average life expectancy of an inmate in general population is 64 years old. Kelly is already 56 years old, and he barely began his sentence. Kelly's health issues do not provide his chances of discharging the EDNY sentence. Additionally, the sentence is imposed by another federal court rather than a state court. Any relevant circumstance for the court to consider is that Kelly's punishment has been enhanced because the government unnecessarily engaged in piecemeal prosecution of him. Presumably, when the purpose of increasing his punishment, in fact, Kelly's Northern District prosecution arguably runs afoul of due process and double jeopardy principles, where the offenses charged in the case were covered by the EDNY's RICO prosecution. Because the government rarely, if ever, prosecutes defendants in separate, simultaneous prosecutions as the government did here, there is no authority to address whether the consecutive sentences will violate due process or double jeopardy provisions. However, the Supreme Court decision in Rutledge versus United States, there's some case law, is instructive. In Rutledge, the United States Supreme Court held that narcotics conspiracy is lesser included offense of a continuing criminal enterprise, and that it is therefore unconstitutional to impose cumulative punishments for both crimes. That means that if one U.S. Attorney's Office prosecuted a defendant for a narcotics conspiracy and another U.S. Attorney's Office simultaneously prosecuted a continuing criminal enterprise for including conduct addressed by the narcotics conspiracy, the sentences should have run concurrently without violating the double jeopardy clause. Similarly, the specific RICO theory advanced by the EDNY prosecutors included that the conduct alleged in the Northern District indictment, the EDNY indictment, alleged that the purpose of Kelly's so-called enterprise was to inter alia, sexually abuse minors and produce child pornography between the years of 1994 and 2018, Exhibit A. The offenses charged in this indictment squarely fall within the alleged purpose of RICO enterprise. No logical reason exists for the government's failure to bring the case in a single indictment except unfairly enhance Kelly's punishment. Even if the consecutive sentences would have not run afoul of the double jeopardy clause, the sentences should run concurrently as a matter of fairness. The government contends. And you talk about fairness. Is it fair that them girls got to live with herpes for the rest of the day? You know what? Let me move on. The government contends that significant incremental punishment is necessary in this case to account for the fact that this case is different from the New York case in nature and in scope. Here, the defendant was convicted of sexually abusing minors, and that abuse occurred prior in time to the abuse of an adult woman and a child victims in the New York case. Government Memorandum at 19. The government is simply wrong. The EDNY indictment speaks for itself. EDNY charged conduct from the 1990s like that charge in this case, including presenting testimony that Kelly allegedly had a sexual relationship with an underage Aaliyah in 1994, like the government did here. The prosecution in the NDNY also presented evidence that Kelly recorded sexual conduct with a 17-year-old named Stephanie in 1999, which constituted sexual exploitation. The scope of the enterprise covered the exact same time period, and the EDNY prosecutors maintained that creating child pornography and having sex with minors was one purpose of the enterprise. Under these circumstances, there was no reason for the government to engage in a piecemeal prosecution except to attempt to enhance Kelly's punishment and perhaps give both the U.S. Attorney's Office an opportunity to hold press conferences. Under these circumstances, the fact that Kelly is serving a de facto life sentence, the court should exercise its discretion and order the sentence in this case to run concurrent to the EDNY sentence. Application factors depends on low guidance range. Section 3553 sets various factors that the court must consider in rendering a sentence. A, the nature of the circumstances of the sentence. Kelly concedes that he has been convicted of serious offenses involving 3 victims, including 3 counts of producing child pornography with Jane when she was 14 years old. The most serious counts of the indictment relate to Jane, with whom Kelly had a 12-year romantic relationship and a seemingly genuine friendship until the government indicted Kelly after the airing of Surviving R. Kelly in 2019. Indeed, Jane would have been happy to put her experience with Kelly behind her until the government revived the case and insisted that she cooperate with the prosecution, including by inducing her to participate with promises of restitution riches. Wow, Bonjean is nasty. Oh, she nasty. As evidence showed, Kelly and Jane text regularly with one another, attended each other's birthday celebration, and frequently socialized, including with Jane's parents. When Jane lost her grandmother, Jane encouraged Kelly to reach out to her mother to give his condolences. Kelly assisted Jane with financial needs long after any claims of obstruction could be made. And Jane told Kelly she loved him. Shortly before he was indicted, when she worried about the impact the Surviving R. Kelly series had on him, she admitted from the stand that her relationship with Kelly was close and friendly as of 2009. That Kelly and Jane maintained a close relationship until he was indicted in 2019 is, of course, not an excuse for the offenses by which Kelly has been convicted and will be sentenced, but to ignore that Kelly and Jane's illegal and inappropriate sexual relationship that began in 1997 and morphed into a lengthy relationship between adults who remained friends until Kelly's indictment in 2019 ignores the full nature and circumstances of the offenses for which he was convicted. This lady is sick as shit. She's sick. She's sick. Importantly, it was not Kelly who placed the tapes in the bathroom in the public domain, which may have caused Jane as much harm as the acts themselves. That Kelly did not produce child pornography for any commercial purposes does not relieve him from criminal responsibility. But if Kelly had been responsible for placing the tapes into the public, the government surely would have to point out that as aggravating evidence. It is most certainly relevant that the tape of Jane and Kelly was stolen by her own aunt and given to the Chicago Sun-Times. The undersigned knowledge Jane's aunt, Stephanie Edwards, as known as Sparkle, was never indicted for trafficking the child pornography. Similarly as to Pauline, she testified that her relationship with Kelly started when she was a teenager another one. similarly to Pauline. So she's trying to say, even if he sleep with your child underage as a freaking baby, as long as they grow into a relationship and their adult age, forget about what they did when he violated them. Wow. Similarly as to Pauline, she testified that her relationship with Kelly that started when she was a teenager also morphed into an adult relationship in which she loved Kelly. Indeed, Pauline testified adamantly that Kelly was wrong for taking sexual advantage of her when she was underage, but she acknowledged that she loved him and still loves him. Again, these facts are not relevant as it relates to Kelly's culpability in the crimes charged, but they are important factors when considering the circumstances of the offenses and its impact on the complaining victims. Conduct must be considered on the continuum of seriousness, and Kelly's conduct, while serious, did not involve some of the aggravation that the type of child pornography cases and sex trafficking cases. Finally, the inducement count as to Nia, count 10, is far less serious than the counts related to Jane or even Pauline. Nia admitted that she sought out Kelly. She moved to Chicago for the summer to see him, insisted on going to his studio. And during an isolated incident in the hallway, Kelly kissed her, embraced her, and touched her genitalia. Nia was either 16 or almost 16 when this occurred, which means it was still illegal. Who the hell cares if she was 16 or almost 16 for a grown man to reach his hand down into a young teenager's pants and grope on her genitalia? He was 28. This incident did not involve threats, violence, coercion, or occurred primarily because Nia wanted to pursue a romantic and sexual connection with Kelly, as she testified to. Of course, a jury found Kelly of an inducement offense as to Kelly, and he faces punishment for that offense. But it does not mean the circumstances of this offense rise of the seriousness of even other inducement counts in this case. There is no denying that Kelly convictions are serious and the harm caused real. Are serious and the harm caused real. But the government's insistence that there is nothing mitigating about Kelly's conduct or life is inconsistent with the actual evidence presented at trial and heard by the jury. B, the history of characteristics of the defendant. The defendant is widely accepted as a musical genius with a who gives a damn. Who cares? The defendant is widely accepted as a musical genius with the rags to riches story. He is considered the greatest living R&B singer and has earned multiple Grammy Awards. He has written and produced music for celebrated artists like Michael Jackson and Whitney Houston. Notwithstanding his legendary status, Robert Kelly is the man with a complicated story that is highly relevant to this court's goal of fashioning an appropriate sentence for him. The defendant has been portrayed by the government and the media as a one-dimensional villain, undeserving of any measure of humanity or dignity. The court is charged with considering the defendant's unique history and characteristics in rendering an appropriate sentence. The defendant's history and characteristics reveal that he is not an evil monster, but a complex, unquestionably troubled human being who faced overwhelming challenges in childhood that shaped his adult life. This evidence is critical to the understanding of how and why the defendant finds himself in a current situation. In this vein, this court must consider the offenses at issue in this case are 25 years old. Contrary to the government and probation's contentions, Kelly did not engage in a pattern of creating child pornography after his state court indictment in 2002. While Kelly was not a child in the late 1990s, he also was not a middle-aged man at the time of this 2019 indictment. In the mid-1990s, the time of the underlying conduct, Kelly was a damaged man in his late 20s with an extraordinarily traumatic childhood that he failed to confront. He lacked the insights or the ability to appreciate the acts in which his traumatic childhood impacted his unhealthy sexual development and harmful choices. As acknowledged in the pre-sentencing investigation report and set out more fully in the extensive reports prepared by Dr. Park Dietz and MD and Dr. Renee Sorrentino, the defendant experienced a traumatic childhood involving severe, prolonged childhood. It says Kelly has attached the mitigation reports that were prepared in connection with the EDNY sentencing and occurred last June. Kelly has redacted those portions of the expert reports that relate solely to his EDNY case. Kelly was unable to maintain or to retain the experts to modify or amend the reports specifically for the use of this case due to the lack of resources. Even if Kelly had access to the resources, the government has restrained his ability to use any resources for his defense. The reports are relevant to the extent that they speak to Kelly's personal history and characteristics. So, saying here that prolonged childhood, sexual abuse, poverty, and violence. His victimization continued into his adulthood where because of his literacy issues, Kelly has been repeatedly defrauded and financially abused even by the people he paid to protect him. Dr. Dietz's report focuses on adverse childhood experiences, illiteracy, and Kelly's positive character traits. Exhibit F report by Dr. Dietz incorporated into Dr. Dietz's report are finding of Dr. Daniel Martel, who conducted neuropsychological testing of the defendant. Dr. Sorrentino's report contains a complete history of Kelly and focuses on Kelly's sexual history, including a detailed discussion of a sexual abuse he suffered as a child. Exhibit G report by Renee Sorrentino. Dr. Shante Alexander conducted collateral interviews in connection with these reports. The reports are lengthy, and the defendant will not quote from them extensively, but will highlight certain portions. Critical understanding and history and characteristics of the defendant is understanding the traumatic childhood that shaped him, as Dr. Dietz writes. Traumatic childhood events such as abuse, neglect, and witnessing experiences like crime, parental conflict, mental illness, and substance abuse can result in long-term negative effects on learning, behavior, and health, often referred to as adverse childhood experiences, ACEs. These types of events create dangerous levels of stress that can derail healthy brain development and increase risk for smoking, alcoholism, depression, heart disease, and dozens of other illnesses and unhealthy behaviors throughout life. Dr. Dietz opines that Kelly endorses a significantly high number of adverse childhood experiences and cannot be overlooked when considering his history and characteristics. Dr. Dietz writes, of Mr. Kelly's problems are now known to be adverse outcomes associated with cumulative ACEs, including but not limited to the below average academic and literacy levels by a kindergarten age, lower school engagement, learning and behavior problems, not complete high school, sexually transmitted disease, having 50 or more sexual partners, anxiety, panic disorder, and criminal conviction. Separately, there is now substantial evidence that a history of being sexually abused as a child is associated with subsequent conviction for sex offenses. As set part in the detail of Dr. Deitch's report, Kelly grew up in poverty and experienced a chaotic home life. One of his longtime employees and friends aptly writes in a letter of support, Robert was born in poverty, but even as a kid, he had passion for music. He shared with me some of the abusive circumstances he grew up in. It was a horrible environment for any child, and Robert is amazingly resilient and have even survived it as a young adult. He was homeless and earning money as a street performer on the frigid streets of Chicago. Eventually, his hard work and talent earned him a record deal. But that deal wouldn't take away his illiteracy or the traumatic experiences that he endured. That was a letter by Diana Copeland. So Diana Copeland wrote a letter for him. It says, Kelly never knew his father. He was raised by his mother and stepfather, who, by all accounts, were heavy drinkers and would sometimes become violently fight. During one vivid fight, the defendant's stepfather pushed his mother, and her dress got stuck in the car door before the defendant's stepfather drove off, dragging his mother for a short while. Her sons threw bricks at his car. By objective accounts, Kelly and his two brothers suffered physical abuse at the hands of his mother, who disciplined them with whippings, with cords, and switches. On one occasion, Kelly's mother grabbed a knife to threaten Kelly and his brothers and accidentally stabbed Kelly in the left arm. Neither Kelly nor his brothers considered the punishments meted out by his mother as abusive. Indeed, Kelly's mother was beloved by her children. He lived in a violent neighborhood with significant gang and drug activity. Kelly steered clear from gang and drug pressures, but still witnessed significant violence that made a lasting impact on him. For example, at the age of 14, Kelly was shot in the arm with a .22 round while riding his bike down the block. Critically, Kelly experienced multiple sources of childhood sexual abuse and premature sexualization that sheds significant light on some of his behaviors. Dr. Sorrentino and Dr. Deitch wrote at length about how Kelly was sexually abused as a child for many years by his older sister. Both of Kelly's brothers report being sexually abused by their sister. The defendant also sexually abused by a landlord and family friend as Mr. Henry. Then Kelly was only 6 or 7 years old. His sister started molesting him. The abuse included oral sex and intercourse and persisted in middle school. Kelly's sister began dating their first cousin, Lewis, and she would have Kelly take Polaroid photos of them having sex. Mr. Henry sexually abused the defendant on a weekly basis during the same general period of time. The abuse included oral and anal sex. Dr. Sorrentino opines that the defendant's history of childhood sexual abuse should be considered as a mitigating factor in his sentencing hearing. It is my opinion, with reasonable medical certainty, that Mr. Kelly's history of childhood abuse is consistent with the definition of mitigating factors as any factor circumstances that lessen the severity or culpability of criminal act. The following evidence supports this opinion. Number 1, Mr. Kelly's history of childhood abuse represents a hardship and circumstance that was out of his control. Number 2, The history has been described in significant scientific literature as contributing to adult hypersexual behaviors. Number 3, Mr. Kelly's adult hypersexual behaviors were factors in his criminal convictions. The defendant suffered other childhood trauma, including witnessing the drowning of his first childhood girlfriend, Lulu, which they were 8 or 9 years old. The defendant and Lulu lived in Chicago Heights, where they were walking near a river when another boy pushed Lulu into the river. The defendant did not know how to swim and began screaming as he watched his friend drown. Multiple sources confirmed this traumatic event and opined that it had significant impact on Kelly. Now, I'm sure that was traumatizing as hell. I'm sure that was traumatizing. I'm sure it was. Kelly is functionally illiterate. Kelly's inability to read and write as a child was a significant source of shame and embarrassment that persists to this day. Kelly was bullied as a child because he could not read or write and eventually dropped out of high school after being held back several times. Kelly spoke of the shame and fear he experienced later in life when accepting Grammy Awards since he could not read the teleprompter. At the time of underlying offenses, Kelly functioned and still does at some degree as a much younger person than he actually is. Even Lisa Van Allen testified that she and Kelly connected because they shared the same interests despite their significant age difference. Kelly's intellectual disability shed some light on why he engaged in inappropriate relationships. Dr. Man Martell re-examined the defendant and reported that he had significant impairments in all areas of academic functioning, placing him in the bottom 1st to 3rd percentiles and at early elementary school level, 1st to 3rd grade overall. Dr. Martell's testing indicated that Mr. Kelly's cognitive abilities were not evenly developed, such as his full-scale IQ, which fell on the borderline of FSIQ 79, does not adequately reflect his overall level of intellectual ability, which is more likely in the low average range. In part due to his lack of school learning, the defendant's illiteracy deficiencies have led to chronic victimization as in adulthood. The defendant has been financially exploited his entire adult life. At one point in his career, he was told he was worth $900 million. He is now destitute. Dr. Dietz also details a number of positive attributes of the defendant as reported by the collateral sources. The defendant is by all accounts a generous and giving person. The defendant has employed his family and friends and continually re-employed them after they stole from him. One of the defendant's friends recounts, "He really has a good heart. He's not a bad person. He has a real forgiving heart, you know. People that did things to him, people around him and sued him and came back. And, he forgave them and gave them their jobs back. And he's real. He's a real kind-hearted person." Another described the defendant as follows. "He's very compassionate and empathetic. When Robert learned of shooting that took place that claimed many lives and devastated a small community in Virginia, he stopped what he was doing and wrote a song called Rise Up, which to this day is still played at every penny, and proceeds is shared by the families, the college, and the community." This was a letter by Alicia Evans. Another time I recall, worth honorable mention, was when Robert saw on the news was a horrific incident that taken place at E2 nightclub in his hometown. There had been a stampede where 21 people were trampled to death. Robert gave 21 families whom he did not know money towards funeral expenses. The defendant also described as down-to-earth and sometimes someone who eschewed the celebrity life, more comfortable keeping those in the community of his childhood. Reports from Dr. Dietz, Dr. Sorrentino, and supporting letters provide additional significant evidence that the defendant's history and characteristics. C. The sentence must be sufficient but not greater than the necessary to satisfy the sentencing goals. The court shall impose a sentence sufficient but not greater to necessary to comply with the purposes of the sentencing as set out below. Number 1, reflect the seriousness of the offense, promote respect for the law, and provide just punishment for the offense. A sentence at a lower end of the guidelines range would reflect the seriousness of the offense, promote respect for the law, and provide just punishment. Kelly has already discussed at length the nature of circumstances of the offenses. At bottom, Kelly engaged in prohibited sexual relationship with Jane and Pauline starting in the late 1990s. Unfortunately, Kelly was not the first or the last man to engage in sexually prohibited relationship with a teenager. Frankly, most men who engage in sexual prohibited relationships in the 1990s and therefore has never paid any consequence for the... Oh! So he's trying to say it's cool when they do it, but it's a problem when I do it. Right? That's what he's trying to say. Frankly, most men who engage in sexually prohibited relationships in the 1990s and before have never paid any consequences for their actions, let alone facing a sentence of life in prison. Any sentence of imprisonment for a 25-year-old conduct reflects the seriousness of the offense and will promote respect for the law in light of the government's apathy towards such crimes prior to the Me Too movement. Moreover, Kelly is already serving a de facto life sentence for conduct that, like that charged here. Any sentence of imprisonment promotes the respect of law where Kelly is likely to die in prison no matter what the court sentences him to in this case. 2, to afford adequate deterrence. At offset, Kelly's 30-year sentence in connections with the EDNY already solves any specific deterrence consideration since Kelly is unlikely to survive prison. The deterrent is serving the de facto life sentence in connection with the EDNY case where the life expectancy of a general population is 64 years old. Kelly is already 56. The United States Sentencing Commission preliminary quarterly data report indicates that a person held in general prison population with a life expectancy is about 64 years old. There's case law to back that up. Acknowledging that the decreased life expectancy for incarcerated individuals based in the United States Sentencing Commission, Kelly would have to defy all statistical odds and make out a prison alive. Kelly's existing 30-year sentence has ensured that he will have no opportunity to commit any crimes in the future. In the unlikely event that Kelly was to survive his 30-year sentence, there is no reason to believe that he would reoffend as a geriatric in his mid-80s. The overwhelming majority of Kelly's criminal conduct was committed a quarter century ago. As Dr. Dietz and Sorrentino confirmed, Kelly is not a pedophile. What? Huh? He's not a pedophile? Is that what this just said? He's not a pedophile? Despite his convictions for child exploitation, where his youngest victims was Jane, who was not a prepubescent minor. As Dr. Dietz and Sorrentino confirmed, the defendant is not a pedophile, and which is a diagnosis that Kelly has never received. Dr. Sorrentino opined that I considered the diagnosis of pedophilia given Mr. Kelly's alleged history of sexual contact with minors. The diagnosis of pedophilia is used to refer to individuals who experience recurrent, intense, and sexually arousing fantasies or sexual urges involving sexual activity with prepubescent child or children, generally aged 13 years or under. I rejected the diagnosis because Mr. Kelly did not report. So you rejected it because he did not report a history of sexual arousal to prepubescent individuals, and his sexual behavior has never involved the pubescent. So you're saying he's not a pedophile because he never told you that he is aroused by little kids. Oh, okay. In sum, no sentence is necessary to specifically deter Kelly, since he is already likely to spend the rest of his life incarcerated. Whatever sentence the court imposes on Kelly, whether it is 10 years imprisonment or something greater than 10 years imprisonment, the sentence will afford little deterrence to the general public, because the general public has no reason to believe that they will be targeted for prosecution and enhanced punishment as Kelly has. The following iconic music stars. Oh, here we freaking go. Here we go. The following iconic music artists: Bob Dylan, Elvis Presley, Jerry Lee Lewis, David Bowie, Jimmy Page, Bill Wyman, Ted Nugent, Steven Tyler, Mick Jagger, Iggy Pop, and Marilyn Manson have all been accused of abusing underage girls. None have been prosecuted and none will die in prison. The government has shown a unique appetite in prosecuting and punishment. Kelly is compared to his white counterparts. Here we freaking go. His white counterparts. It is unlikely that Kelly's sentence will have any deterrent effect on the general public. It surely will have no additional deterrent effect that does Kelly existing 30-year deterrent effect than does Kelly's existing 30-year sentence. The general assumption is that the government must not prosecute anyone but Kelly as harshly and similar conduct. To have a deterrent value, the general public has to conclude that they could face the consequences that Kelly faced if they engaged in similar conduct. The government's failure to focus its attention on other artists and musicians with similar backgrounds to Kelly fails to leave the general public with that impression. Number 3, to protect the public from further crimes of the defendant. Whatever sentence the court imposes will do nothing to protect the public, since Kelly has already been incapacitated by a sentence that is a functional equivalent to life given his age. Kelly has already addressed this sentence consideration in the preceding section in the connection with the discussion about specific deterrence. Number 4, to provide the defendant with what needed treatment. As stated already, Kelly is already sentenced to a term that amounts to life in prison. His sentence affords plenty of opportunity for Kelly to obtain treatment in prison, with which he would comply. But he has little to no chance of being released from prison. As such, this factor is irrelevant. A concurrent sentence at a lower end of the guidelines range will unlikely change Kelly's fate, but it leaves a sliver of hope that Kelly may survive prison and have a chance to die outside of prison walls. This is the best Kelly can hope for, absent reversal of this ED&I conviction. And specifically, the mitigation presents to this court demands that the court be afforded that tiny chance of leaving prison someday when he is far too old to be at any risk to anyone. For the foregoing reasons, The defendant's sentencing of 135 to 168 months imprisonment, a concurrent sentence at a lower end of the guidelines range is sufficient, but not more than necessary to satisfy the sentence goals. Respectfully submitted, Jennifer Bond Jean. Whew. Well, there y'all go. There you go. Okay? So, listen. Okay, y'all can hear me. So, we'll see what happens. At the end of the day, Bond Jean is his lawyer. It is her job to mix things up. This, honestly, reading it is trash to me. Trash. I don't see one winnable part in this for her at all. Not one. Usually I'll find something, I'll be like, you know what, y'all, she got a good point right there. This one, I don't find anything. It was just like she just rushed it and just threw something in there just to have something to say. But at the end of the day, Diva, I'm going to send you this here so you can do your breakdown on it. Y'all, thank you for those who were able to contribute to the channel. I appreciate that. Y'all have a blessed day. I got to get ready to go to work now, but I want to get on here early because I did want to go over this with y'all so y'all can actually know all the details and not just y'all are going to hear. Let me tell you what you're going to hear. You're going to hear some spin from the R. Kelly supporters who are going to say this and say that. You can come right here, read through, and get the actual facts. Okay? Well, listen. God bless y'all. I'll holler at y'all later. Peace out.